aspects of trial vitiation. And I'll highlight 4 or 5 immediately. Very serious. A separate one within those 4 or 5 is 202, which I'll come to separately. But what are those 4 or 5 matters of trial vitiation? Number 1. So I'll give 5 very clear ones. Or rather 4 maybe 4. And the 5th one is 202. Well, 2 of them are ex facie 2 plus 2 is equal to 5 errors. On the face of it. They are related. The 2 are related. What is it, Balas? The learned judge says he bases his sentence. He bases his case against me by saying that, look, Mr. Singhvi, you were warned or admonished by the Supreme Court in the Rafael case. And you had to be more careful. And therefore, because you were warned there, your error here today is more egregious. This is a direct finding at page 567, para 4. So this is the entire basis of sentence. Just see the 4th line, Manas. Further, in connection with the case of SLP so-and-so before the Honorable Supreme Court, I had appeared here, Manas, in the main matter. This is the Supreme Court matter. The accused had sought for the clemency in writing, and the Honorable Supreme Court had admonished him to remain alert in future. Though the accused has committed this offence, further, etc., if he is imposed lighter punishment, will set false example in society. Right, Manas? Now, just note that 2 plus 2 is 5 error. This caution in the Rafael judgment, where the present accused was let off from contempt, is dated 26/11/19. Kindly note the date once.
14/11.
No. Order of Justice Gova is what?
14/11.
You said 26, you said. I'm sorry, a correction was 14/11. That is the judgment of the Honorable Supreme Court, 14/11, not 26. It is common ground that the allegedly offending speech in today's case was made 7 months earlier on 13/4/19. Kindly note that date also. 13/4/19. Now, this is a clear error apparent because there is no question of being retrospectively careful. This speech in Kolar, Karnataka, happened on 13/4/19. The admonition came 7 months later. So clearly, the learned judge misdirects himself. And it is at page 567. Note one more page, in the same volume, in my written submissions, I vehemently took this point of the error at page 671. I said this is a direct error. That's one part of the clear approach to the trial, approach to the sentence, the vitiating factors, why my confidence is shaken in the trial, in the conviction, in the sentence. The second related point is to this, that we are in criminal law. We are not doing some kind of a writ petition or just some affidavit filing. In criminal law, anything and everything, why does the Lordship go to such extent to say, prove the document, show the document, confront the person, put it to him? That's the whole system of criminal law. Sometimes I find it cumbersome, but that's the law. Biggest murder convictions are disturbed on these. Here, this entirety of the Supreme Court reference being the basis for sentencing, none of the Supreme Court, including the order or the record, was put to the accused. In particular, so, Malus, because it is admitted that the sentencing is done within 10 minutes on the same day. That is 23rd of March. Same day, shortly thereafter. As a matter of fact, had you put it to me, possibly the mistake would not have occurred. But that's a separate point. First point is, Malus, under criminal law, you cannot arrive at conclusions without A, verifying. You to put the order, you to in fact prove the order to be very clear, and then confront. None is done. That's point number 2. Point number 3 is more serious. And Malus, I raised this point again in my written submission in the appeal court. That is your lordship's court below, Malus. This is the error by the magistrate. My learned friend has got the entire written submissions here, vehemently raised. The sessions court has ignored this point altogether, that you relied on a backdated event, not backdated, a prior event for a subsequent Supreme Court order. And then when I raised the point, the magistrate hasn't dealt with it correctly. The magistrate never gave me an opportunity to deal with it. You, the sessions court, should deal with it. The sessions court did not deal with it at all. Then, Malus, the third point is more serious. On the date when summoning order was issued, 2/5/19. Summoning order is 2/5/19. Malus, your lordship knows that the bedrock of all criminal proceedings is the summoning order, or most criminal proceedings. It's the trigger, Malus. It's the basis. On that day, when you look at a matter, because my lordship has 100 cases, don't set the criminal law in motion so easily, don't harass him. It's a tedious process, not just sending some summons in a civil matter. It has consequences, reputation, harassment, blah, blah, exemption seeking, presence in court, etc., bail sometimes. So all that wisdom, which your lordships have said, be very careful in the summoning. Summoning order is the bedrock. Now, this was issued on 2/5/19. The point I'm making is that on 2/5/19, the Honorable Magistrate had no, I repeat, zero prosecutable evidence before him. Zero. There's no way he could issue summons, Malus. Why could he not issue summons, Malus? The bedrock of the bedrock. I said the summons is the bedrock, Malus. But the bedrock underlying the summons has to be, Malus, the speech. This whole case is about a speech. On that day, when summons was issued, there was no prosecutable evidence for 3 or 4 simple, obvious reasons. 1, the person who complained was not the audience admitted. He did not say that I was sitting here and hearing Mr. Singhvi speak. 2, his whole case was, I'm talking about 2/5/19. Yes. That I, the complainant, received a WhatsApp which had a account of that speech, which is a newspaper report of that address. That's it. On the day of summons, the WhatsApp is not proved. WhatsApp in any case is hearsay. I get something on my WhatsApp, I can't prove it. I have to get the source which sends me the WhatsApp. The sender is not disclosed. Unidentified. Not known to the recipient, the complainant. Obviously, he has to be known. The only thing is he doesn't want to reveal his name, because how can I receive a WhatsApp without knowing who's sending it? No, something don't be very tough like this. Now, Malus, there is on that day no pen drive. Nothing. It is hearsay upon hearsay upon hearsay on stilts, Malus, as they say. Shakespeare used the phrase, Malus, nonsense upon stilts. This is hearsay upon stilts. No YouTube, no pen drive. All that comes 2 years later. We are not concerned with that. We are talking of the serious vitiation of the trial. How on earth can, Malus, a prosecutable situation arise for me to issue summons? It cannot. This is admitted. What is amazing is, turn to page 30 of Malus, your lordship's CC. I mean, what is worse is it is admitted. Nothing is left to the imagination. May I read it, brothers? 30. Middle. Bang in the middle, brothers. It is, may I read the previous sentence? I have not stated anything in my complaint about the fact of YouTube channel as stated in my deposition. You are issuing summons only on the complaint stage with some minor looking here and there. It is true that I was having WhatsApp message at that time of lodging complaint. It is true that I was not having disputed speech at the time of lodging complaint. But only message was received in WhatsApp. Then the magistrate can't issue summons. What's the point of the Lordship has got so many judgments saying, be careful, be hesitant. It is not true that it can be known after hearing the entire speech whether any speech is defamatory or not. It is true that I cannot state as to how many persons wrote the speech at the place of speech and who gave the said write-up or recording. I cannot state as to whether the speech has passed through how many electronic devices before it reached the YouTube channel or election commission. But in criminal law, the slightest possibility of doctoring, your Lordship eliminates first. Even though you see, I saw it, you say, please send it to forensic first. Here we are talking 2 years later, on that day he is admitting he had nothing. Well, on the top of the same page, this, because the Lordship in this case is going to hear pen drive, YouTube. That is all happening much later. We are talking of prosecutable evidence, date of summons. Now, let us see the 6th line at page 30 itself, above what I have read. It is true that I have not submitted pen drive produced by 21. So the exhibit 21 all is much later. Nor compact disc produced with exhibit 26 at the time of lodging complaint. It is true that I have submitted copy of newspaper regarding news of speech along with my complaint. That's the WhatsApp message I received. That's all. Now, brothers, on that day, my third point is therefore, these are not methods and manners of issuing summons. Brothers, the speech is on 13th of April. In newspaper cutting is done. Note, brothers, 2 dates more. On 14th April, I am told that he files. 1 day later. This is, you can't set in motion the criminal law like this. And on 15th of April, the statement is recorded. Sorry, verified. Yes. On 15th. 15th you said. I see. I'm sorry. So it's 1 day later. 15th is the complaint. 16th is the verification. I'm wrong by 1 day. Then, Manoj, my fourth point is something even more serious. It shakes the confidence of the accused, but also of the system in the purity or the probity of the trial. That's my fourth point. I made 3 points for us: the speech, the Supreme Court point, the non-confrontation point, and the prosecutable evidence point. Now the fourth point is, brothers, and this is even more serious. You have today then reached a stage with me on the date of summons. There is no prosecutable evidence. Separately, I am going to be arguing, I have not reached it yet, that you have never proved by either Evidence Act or the IT Act, nor are you a witness, nor is that reporter a witness, nor has anybody else evidence been proved. That's a separate point, keep it aside. But what happened, Malus, is that having not proved the speech, he, Malus, produces after 2 313 statements have been recorded. Note the date of not one but 2 313 statements. These dates are important, Malus. 24/6/21 is the first 313 statement recorded. 24th June 2021. Now remember, Malus, we have crossed, your Lordship started this in April 2019 with zero evidence. You are now getting 313 on 24/6/21. And the second one is on 29/10/21. This is full 2.5 years, Malus, later. 29/10. These statements are over. He realizes that he has no evidence worth the name. So, brothers, he files an application on 23rd of February 2022 in the trial court, saying, you, the trial court, kindly allow reopening of the evidence, in particular by playing the pen drive, which I have now filed in 2021, 2 years later, and some YouTube CDs, 2 things. Play them to the accused Mr. Singhvi to get some evidence or whatever lordship calls reaction, etc., to record it. This application he files on 23rd of February 2022. Rightly, whereas the trial court records reasons and rejects it on the same day, 23 February 2022, and just glance at the reason at page 159 of volume 1, the paper book. The trial court basically says, the ship has sailed, we are very late now, everything has happened, 313 has been recorded, what are you doing? I can't reopen at your request. That's what the trial court is saying in a nutshell. Come to 159 bottom, para 4. Third line, para 4, 159 of the volume. I'm not on the merits. I'm saying my confidence is shaken in the trial. Look at these events happening. Just see this, what happens. It is prayed. May I read the third line? So the learned trial court is summarizing his application. It is prayed is by Mr. Nanavati's client. It is prayed before this court that considering the evidence and facts brought before this court should give fresh opportunity to the accused to seek explanation, that is, confront him. If the facts mentioned in the present application is looked at, it is prayed that the accused summoned shall be confronted with the questions in connection with that which is produced, namely pen drive, etc. Basically, it's pen drive and YouTube CDs. In this view, now he's deciding. In this view of the statement recorded already of accused under 313 is looked at, specific questions with regard to Exhibit 21 and 26 and the CDs and pen drives have already been put. This was a dilatory tactic, nothing but what he had to put, he had put. This was some kind of a game being played and a serious dilatory tactic, causing great prejudice and suspicion. And he must have decided not to play the electronic record that time, because there'll be no proof till then. Then 313 was something which is already on the proof basis, has to be. So he knew that somebody raised objection. This is an afterthought to delay things and suddenly accelerated. I'll just show that. Specific questions with regard have already been put. Specific question with regard to the evidence brought on record to light have already also been asked. Now see the next sentence. It appears to this court that there is no any other or further important questions left out to be asked. The court further finds there is no defect in the statement. This court does not find it just and proper to summon the accused again and to confront him with his further questions in relation to the produced CD, pen drive, etc. Last para 161, rejected. This is not what I'm pointing out. This is itself serious, that you are knowing it. It was there with you before. Did not do it. Now, against this, he rushes to the 482 to the High Court and gets a stay on 7th of March 2022. Need not go to it. It's at 186, the order. Against his own fault, his own afterthought, his own delay, he goes to the High Court and gets the stay of his own trial, where he's the prosecutor, or the complainant at least. That's given on 7th of March 22. Now note one thing, 7th of March is only last year. From 7th of March to 16th of February this year, everything is hunky-dory. The complainant is happy with his own stay, and he stayed the trial. But more importantly, from 7th of March 22 to 16th of February 23, nothing has changed. There is no new CD, there is no new speech, there is no new witness, there is no new paper, there is no new photograph, there is no new recording, there is nothing has happened. 1 year, exactly 1 year. on 16/2/23, he suddenly, and that will remain an eternal mystery, or although I have lots and lots of guesses, he goes and seeks a vacation of his own stay to activate. And meanwhile, I forgot to give one date, I'm sorry. After 7th of March, one important date I forgot was before that. 4th of March, he's creating a ground. I'm sorry, 7th March, he went to the High Court, Lordship, got that date. I forgot to give a date before that, 4th of March, 3 days before. This is unacceptable. It's clearly some kind of a grand scheme. He creates a fight in the court, trial court, to enable him to go to the High Court. He tells the court that I will not come to your court. The court says it's a part-heard matter, we have to finish it. He then tells the court, yours is not the only court where I have to appear. There are other works I have, other courts. And he then leaves the court in midstream. And then, his right to argue further stands closed. Every word of this is recorded on 4th of March 22. I don't have the page. It is separately, in your Lordship's file, the order sheet. The daily Rojnama has it. Your Lordship knows Gujarati, I don't. Your Lordship can read it. Not here. Your Lordship. We can give your Lordship as Courtmaster, the Rojnama. But on 4th of March, just these dates, I'm sorry I missed out. The dates are 23rd of February, you move this. Sorry, 24th of June, 21, the 313 is recorded. 29th of October, the second 312 is recorded. 23rd February, you file an application. Your evidence is closed on 25/2. Actually, first time it was closed on 25/2. At your request, it is reopened on 28/2/22. Having reopened it on 4th of March, 5 days later, you create a fracas and a scene in court, which is recorded in Gujarati here. Exactly this I have told your Lordships. Yours is not the only court I'll argue. I've got other work to do. I'm walking out. I'm telling my junior to take my, also recorded. I'll take my junior to take my file away. And in effect, with great respect, saying, I don't care. The court then closes it. Take my word for it, don't read it now. Your Lordship will be able to see it. I've examined it with those who know Gujarati. This is 4th of March. On 7th of March, he goes to the High Court and gets a stay. Now comes my final point. From 7th of March for 1 year, no new fact, no new cause of action, nothing new happens. On 16th of February 23, not 22, 23, he suddenly withdraws, comes running back to the trial court. The whole matter is argued and judgment comes in less than a month. The trial and the conviction is over in less than a month. Effectively, there is no trial prior to that. These dates are seeming long. There is nothing happening. You have stayed your own complaint. You have stayed your own trial as a complainant. The 5th point, is the point about 202. That's important. The 16.2 order gives what our Lordship knows as a fig leaf. Because I have to give an excuse. I get a stay from your Lordships. I keep it pending here. 1 year later, I come running to you. Please allow me to withdraw my petition on which your Lordship is given a stay. Whereas normally, I would say that people who are very particular would say, okay, first show me why. Otherwise, I'm going to impose costs for taking 1 year of the court's time by clogging up mine. Now, what is the excuse he gives? Is a fig leaf of an excuse. The reason, give a copy to my lords. Give a copy. What he says here is, appearing submitted that sufficient evidence has come on record of the trial court and the pendency of the matter delays the trial. And see, what is the evidence? Nothing has come. Nothing has come. The first sentence is itself, not a comma, full stop has come. What was insufficient evidence 1 year ago has become sufficient evidence. Hence, he seeks permission to withdraw at this stage, leaving all contentions open. Permission as prayed for is granted. My advocate, Mr. Chaparelli, this side opposes the statement, etc., etc. We will disprove the statement. There is nothing there which has changed. But the record is the same. We have to have the record. And nothing can change. It is a fairly advanced stage. 313 was over. Your right to argue, you had destroyed yourself. What can change, Malas? Now, well, 202, the point is, let me summarize the point, because your Lordship is well aware of 202. Let me first give your Lordship, then I'll only read two portions to make it quicker. The point here is number one. 202 was created by an amendment. It was not there always in this form. And the underlying material before 202 said, you have to have it as a mandatory requirement because of preventing or minimizing abuse of process. And it was classically made for cases like ours, of Kolar versus Surat. Classically, it was made for that. I'll just read one, it will become clear. Having amended the law by amendment and inserted it, a debate arose whether it is mandatory or half compliable or directory, or you should try to comply, but you can ignore it. That debate was settled in several cases. The particular one is Dhanuka's case, which is followed in many cases, that look, it is mandatory. So that's point number two. Held, so the first, the rationale underlying the amendment, this is an abuse. Something happens there and you come to Surat to do it. Please have an inquiry. Second, is it mandatory or not? Settled, it is mandatory. Third, flowing from mandatory itself, it's an interpretation, it's only an inference, but it's an established inference. If something is mandatory and I raise it today or I raise it 2 weeks later or I raise it late, it will make no difference because your lordships have to take the bar itself even if I don't raise it at all. Suppose I don't raise it. Well, suppose I don't raise, but your lordship is staring in the face limitation. The lordship says, you didn't raise it, I won't touch it. That's not the law. When judgments have held it to be mandatory, irrespective of whether you raise it or not, you are the court, you are obliged to take it. That's point number 3. Point number 4, the trial court records various submissions, but deals with it in one sentence, that you raised it late at the time of hearing, final hearing. That's the only point. That cannot be if it's mandatory, Manas. Whether you raise it or not, you are. And he then cites one para again and again. After verification, seeing the file, looking at everything, I've issued summons. And the learned judge, magistrate, and more importantly, the sessions court says that is sufficient application of mine. So the fourth point is, the sessions court commits a clear 2 plus 2 is equal to 6 error again here on this count. What it does is, just note, at volume 1, page 73, don't go to it now, just note the point. At 73, the sessions court underlines a passage in a case called Sunil Todi, saying that this passage suggests that it is not mandatory. Now, Dhanuka is anyway against it, it's clearly. But what the learned sessions court makes a clear 2 plus 2 is 5 error is that what he underlines, saying it is from Todi which holds is not mandatory, is not a passage from Todi at all. It is a passage from another constitution bench of the Supreme Court, totally different case, which held that there may be some debate earlier that under 138, only 138, check bouncing, it may or may not be mandatory. But we, the constitution bench, hold that it is mandatory. There's a debate between this case and this case, which says in 138, he says it's not mandatory, he says it's mandatory. So the constitution bench had to iron it out. There also they held it to be mandatory. The learned judge underlines and misreads this to say, this suggests it's not mandatory. It's completely wrong. So this error by itself, the first error of the learned trial court is there is no inquiry. There is one delightfully vague para, having considered all the papers, verified, I proceed. That's not 202 doesn't require a judgment, no doubt. But 202 doesn't require that having seen the papers and summoned the witness, automatically 202 is complied with. Where is the inquiry? Whom have you said? Did you send any constable for inquiry? Did you send any? You can do anything you like. And the inquiry can be many forms. Where is the inquiry? Nothing. The only sentence then given, knowing that that is wrong, is that you came late. So these are 6 errors which are serious. And this is sufficient as the 6th point to vitiate the trial. These are all matters which will be bound to succeed according to me in the trial, in the appeal court. Therefore, I need an interim protection. Now, what are those pages? We'll just see very quickly. The error occurs firstly at 73. Well, this system everywhere in the judgment is underlining what I'm relying upon. That's what he does. This is kind of way of putting a finding for the learned judge. Now, 73. Well, this para 10 is what he relies upon. Just note para 10. And your lordship may note on the side, this is not toddy at all. This is a extract. Para 10, just I have to go a little slowly here. Para 10 at page 73 is para 10 of a constitution bench. But it forms part of para 45 of Todi. Because Todi has quoted another constitution bench is point 1. Point 2. It clearly holds it, Willis, in the actual judgment if your lordship goes to Todi. Page? Same?
Yes. Judgment.
Kindly go to 183 of judgment's compilation. Where is it? Starting page?
183.
183. I'm grateful. One second. 183 first. Well, it starts at 183, come to 195 straight away.
Yes.
There it becomes clear what is Todi, what is non-Todi. Well, at 195, your lordship has got the same para reproduced. And then, Wallace, para 45 starts at 195 lower part. And your lordship sees the first line regarding expeditious trial of Negotiable Instruments Act 1881. That is well as the context. And then if your lordship continues after 45, he quotes that constitution bench. And even the constitution bench says that ultimately in para 11, the next para at 196, that there are two views. We will accept the amicus curiae suggestion that even in 138 it should be mandatory. That's the end of para 11. The learned, that's well out of the last line of para 11.
Yes.
The learned amicus curiae recommended that the magistrate should come to a conclusion after holding an inquiry that there are sufficient grounds to proceed against the accused. We are in agreement with the learned amici. So clearly, Mills, that judgment approach in the Sessions Court is wrong. And just note the paras of Todi which hold it to be mandatory, para 38 at 193 and para 39 at 194. Please take my word for it. It holds it to be mandatory. Para 38 and 39. Yeah. 38, 39 is direct finding. 38, 39 is a direct finding. Now note below Vijay Dhanuka, which is the main judgment followed everywhere. 201 and para 12 is clear at 207. I'm saving time not reading it. Your lordship is only concerned mandatory holding in the para. Holds it to be mandatory at 207 para 12. It says the words are shall. It says there's a law commission report. It was amended. Shall when it says the lower part, shall can mean may, but here shall means shall. In one line, that is the summary. Para 12. Then, Malats, the only basis. One more case is very important. The little noticed case, very, very important. Pawar's case. Pawar says that because it is mandatory, it doesn't matter when, even you can raise it for the first time after 2 appeals in the High Court. That is Pawar. The other compilation.
It's in the other compilation.
I'm sorry, this one was left out, so it is put in the other compilation. Show me.
I'll just give you. Page 106, 109, para 23.
Page 106 at 109. I'm sorry.
106 and 109. Para
I see both.
23.
106 was para 23. Where is Pawar?
So it's many.
Oh, I see. Just give me a minute, but I'm sorry. It's Abhijit Pawar was added later on.
Admitted position and laws.
Now, let's know where it says to go to High Court also. Well, para 23 at 106 starts the vital necessity at 10. Then 24 is Vijay Dhanuka. And then, Malus, just see.
Again, 26 also Vijay Dhanuka's reference.
Lordship. And then see, Malus, 30 is the important para. I was looking for that. Of course, you should raise it early. But if you fail to raise it, just see 30. 30 is all that I'm interested in, because the only ground given against me is that even in the High Court could have considered this argument on merits. That middle sentence is 30. So where you have failed to, because it's so important, mandatory, you should. Here, Manus, who has considered it? Now see, Manus, how the Sessions Court has dealt with it. The only reason given is, first see the magistrate, Manus, and then see the Sessions Court. See the magistrate. Just give me the Sessions Court, because Sessions Court has dealt with the magistrate. Just give me the Sessions Court.
73.
Sessions Court says two things. One, the High Court, the magistrate has dealt with it inter alia because you came late. More importantly, it quotes the magistrate same para 5 times, 3 times. That the magistrate said, I have applied my mind.
75.
Up to
Verification
75.
was done.
The only mind that Paisa applies is use of formula words, giving my thoughtful consideration to all the materials, verifying the complaint, etc., getting the statement and reading the complaint, I am issued. No mention of inquiry. Where is the inquiry has to have something. I'm not saying that a lordship will put up a board saying inquiry, invite objections, have a commission of inquiry. Something has to be done to go somewhere. Now see, based on the above, it's 75. It transpires that the magistrate, after giving thoughtful consideration, verification, and subsequent should never challenge at any stage. Hence, the objection is being vitiated due to lack of data can be accepted. Then what is the other part of this? Another part. Show the magistrate. Show the magistrate. Show the magistrate here. I'm sorry, but just give me a minute. Page. Magistrate. Yes. Leave it. I just show the magistrate page. Repeated that formula words again and again. I just come to it. My next, I conclude on 202 saying there is otherwise a clear vitiation. The answer given is it's late, but the more particular answer given is the other formula words I've used. Therefore, it's deemed that I applied my mind. There is no evidence of inquiry. Therefore, it is well as clearly wrong. I raise it before the Sessions Court. No answer except page 75. That's the answer. Then, well as no documentary proof of speech is in that sense my last point in terms of the merits. That well as is clear.
So paras are 20.1 to 20.
I'm sorry, well as this is a little late in coming.
20.1.
This is at page 535.
Para 20.
20.1 onwards, yes.
And it goes on till 20.3.
I-31.
Yes.
I'm grateful.
Yes. Yes.
This is the entire Wallace case on 202. So Lordship will read to 20.1
Yes.
and then come to page 536 over the page.
Yes.
Whereas in the present case, the order of process is not challenged by the accused in the apex court till date. In the present case, the entire trial and the issue has been raised at the stage of argument. In the above judgment, defense has been raised, not order the case, the procedure shall be vitiated. This I have just read Pawar Balu, which says even the High Court level it can be raised. And then 540 is 20.3. As per the principle laid down in the above judgment, if inquiry is not conducted, trial is not vitiated, defense could not show what prejudice, etc. This is Malu's the totality. And he says basically that I have applied my mind generally to all the papers. But it is clear, therefore, that inquiry, even the judgment suggests inquiry has not been done. It's blaming me for not taking it to the apex court. Now, Malus, I come to this documentary proof not existing. Just note in simple form what is the issue, Malus. Now I am on the proving of the one part is, Malus, that on the date you had no prosecutable evidence. Now on the date of conviction, you had no admissible evidence. That was on vitiating. Today, Malus, how do you convict in criminal law on this? On criminal law, you can't convict whether on an affidavit or on my say-so. What is this point? Well, just note, I'll break it up. First point.
Yes.
WhatsApp cutting has not been proved. And on instructions, I say it has not even been exhibited.
No.
I'm breaking it up, bullets, about 10 bullets will be there.
Yes.
But we'll just see. WhatsApp is not exhibited, not proved.
Not true.
The entire basis is the WhatsApp. The pen drive, exhibit 21, not produced with the complaint. No mention of the pen drive in the complaint. It comes over 1 year later, around November 2020. And it is exhibited subject to a caveat. Your Lordship sometimes does it, but says clearly, subject to on the condition of proving it. Never proved. So exhibit is irrelevant. I would call it not exhibited. But if your Lordship exhibits something saying subject to it being proved, and you don't bring any proof till the end, it amounts to be not exhibited. It is not exhibited. And trial is over, I am convicted. The entire basis is only twofold. One is whether this person can maintain a complaint. Second is on the basis of a speech which is on a WhatsApp. There is no pen drive, not exhibited. Then fourth, there is no 65B certificate. Well, it sounds like something technical. No, the very important thing, the Lordship is upturning big matters. No 65B certificate to support the recording. Then that's why I say something very interesting happens. A miracle man appears. Now we come to CDs. Now CD suddenly appears from the Election Commission. And the story is that Election Commission gave it to a miracle witness called Yaji. I'll tell you why the miracle witness. This Yaji Malas admits in writing at page 44 of the CC that I am heavily involved and office bearer of very important positions at the local level in the BJP. And a close friend of the complainant, he says it, these are not my words, and operating with him in all this. Because you know that till 2021 you have no proof, you suddenly in desperation produce this Yaji. Yaji Malus is directly, intimately connected with the complainant. It is as good as the complainant himself saying, there's no difference. And he becomes the sole basis and nothing else of Malus supposedly verifying the entire element, contents of the complaint. Yaji is admittedly not named in the complaint. He is not born in the list of witnesses. In fact, he is not present till the late 2020 or early 21, 2 years later. So, Malus, the totality of all this is Yaji. No WhatsApp, no pen drive exhibited, a CD appearing 2 years later, not verified, only person is Yaji. Now see two parts of Yaji first. Come to CC1, page 44. Can this witness be a basis of my conviction, Willis?
Two more things he admits. He admits that he didn't get CDs in a sealed condition. That's point number one. And second thing, he admits cross-examination cannot be ruled out.
As your lordship reads with me this Yaji, two things. Ganesh, Yaji.
Exhibit 67.
What is PW? What is it?
No,
This is page 44, Balas.
So they give exhibit
Refer to
number.
by name and
Your lordship gives exhibit numbers apparently. The exhibit, it's page 44 of the CC1. Let's use that one, of the compilation. Now, well, this totality is important. Well, Yaji is, I am sorry to repeat, is very important. Yaji is A, brought in, not in the complaint. B, not in the list of witnesses. C, comes almost 2 years later. D, is a complete close associate of the complainant and holding official positions in the BJP. E, well, in all such matters, your lordship has to have clearly some clear evidence of non-tampering from something which came from the election commission, came to my hand. There was so much tampering. There is a statement that tampering by him, that tampering can't be ruled out. And well, there's no other proof apart from this Yaji CD because there's nothing in the WhatsApp. On these points, just turn to page 44. At present, I am cultural advisor, lower part, of the Chief Minister of Karnataka. In the year 2019, I was regional director in the BJP. I did not know the position of regional director. Generally, in the regional office, I am supposed to convey the instructions coming from the BJP center office to district and taluka levels and to execute such instructions, and to submit a report to the regional and central office. The last Lok Sabha elections were held in the year 19. At that time, my duty as a regional director, and since the Lok Sabha elections were ensuing, I was given some extra work from the party. Various departments like tourism department, legal department, publicity material distribution department, and my duty was to carry out liaison working from the representative of the party with such department. Pretty large canvas. It's come down below the same page. Apart from the aforementioned responsibility, I was instructed to attend a lot of public meetings in the year, that year is wrongly typed, 2021, I think.
2019.
Oh, I see, this is wrongly, 2019. 2019. That typo will be corrected, it's 2019. A public meeting of our national president of BJP was held during 2019 Lok Sabha election at Honali, and I had performed the duty to attend such meeting and to carry out translation work of the lecture given by Shri Amit Shah in Hindi into Kannada language and hand it over to the regional office. One public meeting of the then president of the Indian National Congress held at Kolar on 13th April, where I was supposed to attend the said meeting and hear the issues upon which Shri Rahul Gandhi gave speech in the said meeting and to submit a report. On that day, I had left from Bangalore, etc. Then he goes on. Okay. Kindly, so this is only for the positions he holds. I'm not good. Now note, Balaj, how I deal with the whole thing at one place at 6:65 is my written submission. And it can't be ruled out. Ruled out. I'm sorry, but it's 56 also before Lordship leaves it. 56. Last line of 56 is the ruled out thing. Rahul Gandhi had said bottom in that speech. After that was right at the bottom. Right at the bottom of 56. The CD bearing 26 does not cover the entire speech of Rahul Gandhi. And then was how much, next page, total how much speech of Rahul Gandhi has been left out in the CD. Some sentences have been left out in all the 3 CDs. That can't be ruled out. Tempering, where is that? Then was tampering was some suspicion raised because he says it was lying in open condition at page 52. It's not sealed, it is not sanitized. See the bottom of 52. Find out. Can't be ruled out. It is true, bottom of 52. It is true that I received this CD in open condition. Mark the word open condition from the Election Commission. I had not stated election, given me this CD, etc. I'll give the exact sentence where about at 4th line was, I am not aware as to from where the Election Commission obtained it and made it. It is true that I have not seen the original CD lying with the Election Commission. It is true that I handed over the CDs being exhibit so-and-so to Raghunathan in the same condition as I received. Then again he says open condition, 4 lines later. Received them in open condition. And then next para he says in page 10, I am associated with BJP for 45 years. It is true that since I am senior, I have been given various designations. I was secretary of BJP regional office, and then he goes on with this, cultural advisor, etc. Now, my summary, you also will note. I mean, I don't want to. At 665 is my summary of volume 1 of the main volume, 665.
Yes.
Because we are now on proving the document in any of the 3 ways. 3 ways. Which way have you proved it is for your lordships to consider. Prima facie. No way have you proved it. 665. Para small Roman 2. In the detailed grounds of appeal of these submissions have been summarized. Second sentence in II. It is the clear and concise case of the appellant that the following documents electronic record was never proved in accordance with the law. Therefore, the complainant is not entitled to refer to this material to prove the contents. The complainant miserably failed to prove the cutting of the newspaper, forming the very foundation of the complaint, which he claims to have received on WhatsApp message and pen drive, incorporating the same in accordance with law. In fact, the complaint in question could not have been entertained at all on the basis of this material. Further, the complainant has miserably failed to prove the content of 3 CDs, marked as 26, statedly obtained from the Election Commission. Further stated that 3 DVDs marked as 126 remain unproved. The next para. The documents were marked only for purpose of identification, subject to the condition. It's as good as not exhibiting. Subject to the condition makes it clear it's not exhibited. This issue is further required to be examined in the light of the fact complainant took the issue to the High Court with a prayer for examination of additional witnesses. It is after this exercise that DVDs were brought on record. They still remained unproved. Significantly, this complainant went to the High Court again because it agreed by additional trial court, declining the prayer to put, I saw that was the order, put the contents of the electronic documents as having not been proved. In this regard, an ex-chair giving the details of the petition. Lord remember, 4th of March, he went to the High Court. He said to confront me with all that. High Court, that matter was pending. The trial court had said, no, we can't confront. It is therefore crystal clear that the documents referred to above have not been brought on record in accordance with law. It is for this reason the contents by playing the devices were not put to the appellant. The escape route of relying upon the so-called admissions made in the statement is patently misconceived. A bare reading of 313 makes the factual situation patently clear. No point of time did the appellant in any manner accept that the so-called incriminating material formed part of the speech delivered by him at Kolar. The judgment cited is patently inapplicable. Now let us see B. B is the Yaji point. Faced with this impasse, In utter desperation, the complainant examined a veteran party man, Sri Yaji, Exhibit 67, as a witness claiming to have heard the speech. Though this witness had been associated with the proceedings from an early stage, it was never whispered that he had attended the meeting in question and heard the speech. That's why I call him a magical miracle man. This witness appeared in court after a long delay of 2020. Well, this is 2 years afterwards. He therefore claimed to exactly remember the contents of the oral speech heard by him time back. He failed to prove that he had prepared any written note or report of what he had heard. Detailed grounds in this regard are found from 55 to 57 of the memorandum. Oh, I'm sorry. I'll take a very short while after. Very, very short while. DP of life.
before my, let 2-3 matters. Yes, after that we can proceed.
May I request for cancelling? I'm requesting for circulation of criminal appeal to the press. Since 10 days I have filed, but
Yes.
office notice not placing on point.
Why?
Unless
If
court
there is any
permits
ob-
will not, it will not be listed.
If there is any office objection.
No
is-
objection. Without any objection. Please.
Tuesday.
Choose, please.
Pass over matter, serial number 2. Ms. Jayashree Bhatt, learned public.
Yes,
Yes, ma'am.
here regarding my lord temporary bail on the ground of sister's marriage.
Yes.
The marriage is going to be performed on 2nd May, my lord. Ceremony starts from today, my lord.
After conviction only 11 months
One,
and he
one
is
year,
convicted for the offense punishable under section 489 306. No case is made out.
my lords are not inclined to
Yes, I am not
permitted to.
permitted to.
Serial number 3. Part in person, Chetan Kumar Thakur through Bharat Thakur.
બોલો લગ્નમાં ઘણા બધા છે કુટુંબીઓ કન્વિક્શન હજી હમણાં જ થયું છે ખાલી 11 મહિના જ થયા છે જેલમાં આ લગ્ન છે બીજા ઘરના એના સગા આ તમારા ભાઈના નથી બાકીના ઘણા બધા માણસો છે પરિવારમાં આખું લિસ્ટ બનાવ્યું છે તમે પરિવારના સભ્યોનું applicant is convicted for the offense punishable under section 363 read with section POCSO 6 of the POCSO for a period of 10 years and only 11 months he is actually undergo as a prisoner. No case is made out. Application rejected.
Serial number 8, Mr. Sandeep Limbani, learned
ભાઈ આમને આની
ના મંજૂર કર્યા.
Twice the matter is called up. The learned council will remain present and in the interest of ત્રીજી કે ચોથી તારીખે રાખો
4th of May. For court board, serial number 1, Mr. Anil Rathod, learned public prosecutor.
yes Mr. yes
On the ground of the petition, lawfully passed over petition. Their certificate of statement of fact.
the 2 months whether this can be
3 months, 28 days.
for a week we can present applicant is convicted for the offense punishable under section 306/498 into bracket C of the IPC for a period of 10 years. The present application is on the ground of the real nephew passed on 26th of April 2023. Considering the death certificate issued by the competent authority, the applicant convict is to be enlarged on temporary bail for a period of a week from actual release. No further extension would be considered on any account. You will need absolute direct service permit. Yes.
Bartered met of the first session. Number 7, Dr. Abhishek Manu Singh will next advocate. Yes, Chapandre.
Just 3 or 4 points.
Yes.
3 points and one wind up. The first of those 3 points is the learning session scored at page 70 of volume 1. The point I just argued before lunch that
Yes.
this evidence is not admissible without some degree of proving. All those things I gave a lot of steps. All this is put to him. He literally, with his great respect, rushes it aside in a very perfunctory paragraph at page 70.
Yes. Second part.
I'm grateful. As per the submission of Reserve Mr. Tolia, during the deposition of Judge, he was shown the video of the speech, and the CD was produced only to corroborate the version of witness, not required. It transpired that the junction level trial court is rightly relied upon evidence of Judge and bias. I believe that the discussion of admissibility is the entire case.
Yes.
I believe that the discussion of admissibility in court of proof of electronic evidence would be required to be made at the time of final hearing. Moreover, the evidence, because it is all of them will be made to final hearing, it is the prima facie nature which justifies an interim enlargement on the ground of A, no sentence, and B, no conviction. And for that, your lordship is entitled to opine as an interim measure. Then the second point is another error which happens at page 82 or 7, 8, 10 pages later. The
Yes.
same order. That is the error. This is a gross error. A reliance is placed for holding against me by reference to your lordship's High Court judgment
Yes.
in Manus Vika Bhai Kacharia's case.
Narayan Bhai Kachari.
Narayan Bhai Vika Bhai Kacharia's case.
Hmm.
And that is Manus clearly at 82 starting and then going on and concluding at 83. And it is enough, Manus, note the 83 part where the conclusion is as envisaged by Honorable High Court Narabai. This is kindly mark the word Honorable High Court. Your lordships of the High Court denied stay of conviction. That's it. Now this is a serious error. I am not on the merits for this. The Supreme Court may be on 10 grounds, it may be partial, it may be because of a particular. But when you as a learned sessions court cite a Gujarat High Court judgment, you have to take care to see that it is not reversed. This judgment has been reversed admittedly by the Supreme Court. I will not go into the Supreme Court order. It's at 681, 684 of the volume 1 of the compilation. I'm sorry, not compilation, volume 1 of the
The
judgment.
judgment. The
Judgment.
spiral down.
This you also will not read, go into it, just go down the date.
Just
The date is
6 page number.
The judgment starts.
date 29 April 2016 is the date. The judgment starts at page 681.
The last judgment.
And they hold on multiple grounds, but it's also separately held on the ground at 683. So lordship starts the judgment at 681.
Yes.
And your lordship, I'm not concerned with the merits for this. You can apply the High Court, Supreme Court, you have said this so interpretation, but ultimately you are making an error because you are assuming that the Gujarat High Court is final. This is a reversal. See, the penultimate para at page 683.
Yes.
Under the circumstances, it appears to us, looking to the facts of the case, that adverse consequences will certainly follow, not only to the appellant, but also to his constituents, in case the conviction remains. The impact would virtually be irreparable. That's all that I am with. And they then reverse it in the last trial. The High Court said no, the Supreme Court said yes. The third point on which I wish to end the merits.
No, this one.
Now this third one is Hardik Patel,
Yes.
who again got a rejection from the High Court. But it was reversed by the Supreme Court on 12th of April 2022. I'm sorry. It was reversed by the Supreme Court on 12th of April 2022. They say, only one line, the High Court ought to have suspended conviction, is what the Supreme Court says. They say it at page 2 of the order handed over. Rest is not relevant. They have leave granted. It's against, Lordship may take it. It's against a High Court order which said no stay of conviction. And then let's come to para 5. Para 5. Having regard to the facts and circumstances, we are of the view this is a fit case not only for suspension of sentence, but also for suspension of conviction. The High Court, in our view, ought to have suspended the conviction as well. Well, it has brought me to the end. Yes. These are also the serious offences, including 427 and 435. Now, that brings to the end of the submission. I'm very grateful for the time here. I want to end by saying two things.
Yes.
One, at the end of the day, when a person has suffered conviction, the issue whether your lordship would stay conviction or not is largely between your lordships and the accused. It cannot in any remote manner concern a complainant.
So your main thirst is that they are not entitled to give any audience because
I will not put it as that
Yes.
strictly as audience.
Yes.
I'm saying see the larger picture of the weight your lordship will give to that
Yes,
audience.
exactly.
I mean, I could put it as your lordship is saying, but I'll not go that far. Even if your lordship were to hear them, which I don't think your lordship should be in any elaborate way hearing them,
Yes.
the weight given to them has to be judged in this matrix. What is the matrix? That you, the complainant, have brought an attention of a crime. You have prosecuted it. You have got a conviction and you have got sentence. Is it not strange that you have not at all bothered about the sentence?
Okay.
But you are now bothered about the conviction stay because you want that no, sentence apart, punishment apart. This man must be disqualified. That is, if at all, in the realm of politics. It is in the realm of ROPA. What concern do you have with ROPA? Who are you? You are a complainant. What is your concern? This can't be a legitimate concern. This can't be a legitimate concern. It can, of course, your lordship is administering 389. So lordship will administer 389 according to what is your lordship's understanding of the law. But a complainant says, I must be given dispositive or I must be given great weight because I don't want Mr. Singhvi to remain in parliament. That can't be a test. The second thing I want to end on is the single most important point of this is all such provisions, 389 in your lordship's Arbitration Act, interim relief, civil suits, order 39. All of them have one basic thing. What is the balance of convenience? Now, I am ending on this, so let me summarize everything in bullets. The balance of convenience is a hodgepodge of these 5 or 6 obvious basic factors. And I cannot think of any case more weighted in favor of these factors than my case. I may be guilty of exaggeration, I may be wrong, but I am putting it to your lordships. 1. Is it a serious offense? My answer is with great respect, the answer must be no. It is nothing in the nature of murder, rape, abduction, 5 years, 7 years, 10 years, life in prison. Number 2, is it without being a so-called serious case, a case of moral turpitude? That would be corruption, maybe some degrees of sexual offenses or other things. No, this is admittedly not that. 3, is it an anti-societal offense? Well, there may be, I can't think immediately, but there may be beyond these 2 categories, something which really creates, I would say, for example, creating enmity between sections. It may not have that much of 153A, etc., but it has a great societal impact where the interest is not only of Mr. Rahul or me, but is of the state to maintain an order, law and order. Therefore, that also, I'm not that. Number 4, is it a non-cognizable and bailable? Well, clearly. Number 5, is it one which can only lead to simple imprisonment? It's only one out of 22 such. They have hundreds of offenses, only 22 such. Number 6, these 5 are enough to stay conviction. But here, per se, there is a sixth ground. And I submit that per se ground is sufficient. Per se ground is, you are a legislator, yes. Will you lose your seat? Yes. Even while you don't lose your seat and before a new election is held, will you be able to attend parliament? No. Will you lose your seat after 3 to 6 months? Yes. Will the new man who comes be liable to be reversed and you reinstalled if you win your appeal in 9 months? Answer no. Malas, what better case then can be for getting a stay of conviction when the consequences of non-stay of conviction are so drastic and more than drastic are so irreversible by the very nature. Even in civil matters, your lordship has the capacity to compensate it by money, to reinstate me in my house. Here, the shot is fired. You can't get the bullet back. The horse has run, nothing. No other way of coming back. And lastly but not the least, if I don't get conviction stay, I am otherwise, apart from all these 7 consequences, I am debarred from contesting for a period which is virtually semi-permanent in politics. They say a week is a long time in politics. We are talking of 8 years here. Therefore, I beseech my lords to consider this is not a serious crime. I have done no murder. It is given for the asking in even every small case. In bigger cases, it is given with circumspection. As I do not deserve this, your lordship may consider it. I'm very deeply obliged for a patient hearing. Please.
Yes, Mr.
Please.
First you start,
Right.
we call upon you.
Sir, I would like to respond firstly to the submission with regard to the locus in context of further submission that it is to attract the camera. My lords may kindly look to section 389, which had been applied for the purpose of staying the conviction. Yes. So this particular section falls in chapter 29.
Yes.
Now, so far as this revision application is concerned, it is in furtherance of the appeal filed by the petitioner.
Yes.
Appeal is under section 374. And in context of that particular submission, my lords may please look to section 386.
Yes.
Powers of the appellate court. After perusing such record and hearing the appellant or his pleader, if he appears, and the public prosecutor if he appears. Therefore, so far as locus of public prosecutor is concerned,
Yes.
regardless of it being a private complaint proceedings or a first information proceedings, legislature, so far as this particular chapter where 389 has been there, permits public prosecutor a right of audience. Taking this issue to the section 389 itself, Honorable Court may please see the occurrence of the term may. Pending any appeal by convicted person, the appellate court may. Before emphasizing this term, kindly please see the proviso. In both the proviso, public prosecutor had been found to have locus so far as any application under 389 subsection 1 is concerned. In view of that, my submission is that public prosecutor has statutory right of audience so far as this particular chapter is concerned. Now, in context of section 389, where the term may had been used, that clearly signifies that it is certainly within the parameters of the different judgments which would be applicable and binding to the Honorable Court. But ultimately the term may fully signifies that it is the discretion of the Honorable Court one. And at this stage, when the legislature had permitted the sentence of 2 years, the learned magistrate, in context of the gravity of the matter, had found that here is a fit case to award the punishment which is permissible under the law. It is not that punishment is beyond the capacity or competence. It is within the permissible limit. So this is not the stage to agitate the aspect of quantum of sentence. This is the stage where Honorable Court may certainly look into very peripheral aspect of seriousness of the offense. But learned magistrate as well as the learned session judge had come to the conclusion, appreciating the material of investigation, that it is a serious offense in terms of the acts committed by the petitioner. Sir, therefore, I would very humbly submit that this is not a case where Honorable Court may exercise the discretion of staying the conviction. So far as other reliefs are concerned, learned magistrate initially and thereafter learned session judge has already considered. Therefore, sir, this is not a case where Honorable Court may consider staying of the.
What about the lacuna which is he has pointed out about that?
Sir, so far as those lacunas which my learned senior friend had placed before this Honorable Court, I would very precisely submit that those lacunas are, if at all found, this is not the stage to scrutiny or scrutinize those aspects. Say, for example, 202. All these aspects were to be agitated at an appropriate time. In this particular proceedings, agitating those issues probably is not warranted at this stage. Probably are not required to be considered at this stage. What is important is this, that learned magistrate, considering the evidence placed before him, had found that this is the fit case to convict a person or convict the petitioner for the maximum term which is available in the statute, and that he had done. Learned special judge, session judge, after considering submissions as well as material which was placed before him, had also approved that particular aspect. So the scope of the revision application probably is just to see and examine whether there is any perversity.
Is filed under which section? What is the scope of that?
Sir, so far as petition is concerned, it is filed. If Honorable Court kindly permit me to point out from the memo of petition,
Yes.
it reads like this. Under section 397, read with section 401 of CRPC against the judgment and order dated 20th April 23 below exhibit 5 in criminal appeal number so and so, so and so. So my lords, so far as memo of application is
Now
concerned,
kindly read the provision 397 read with section 401.
my lords, I may do that. I may. Sir, here also certainly I will be reading this particular provision, but again the three term which has been used in the provision: correctness, legality, and propriety.
I need that.
I may read. The High Court or any session judge may call for and examine the record of any proceeding before any inferior court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. All magistrate, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior to the session judge for the purpose of this subsection and of section 398. The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings. If an application under this section has been made by any person either to the High Court or to the session judge, no further application by the same shall be entertained by the other of them. Now, one aspect which my learned senior friend probably had not put before the Honorable Court is whether the order which has been passed could be construed as a final order or it would be construed as an interlocutory. But keeping aside that aspect, I may read 401. In the case of any proceedings, the record of which has been called for by itself or which otherwise comes to its knowledge, and the High Court may, in its discretion, exercise any of the powers conferred on the Court of Appeal by section 386, 389, 390, and 391, or on a Court of Session by section 307, and when the judges composing the Court of Revision are equally divided in opinion, the case shall be disposed of in the manner provided by section 392. No order under this section shall be made to the prejudice of the accused or other person unless he has an opportunity of being heard, either personally or by pleader in his own defense. Nothing in this section shall be deemed to authorize High Court to convert a finding of acquittal into one of conviction. Where under the code an appeal lies and no appeal is brought, no proceedings by way of revision shall be entertained at the instance of party who could have appealed. Where under this code an appeal lies but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under the erroneous belief that no appeal lies thereto and that it is necessary in the interest of justice so to do, the High Court may treat the application for revision as a petition of appeal and deal with the same accordingly. Sir, another submission which my learned senior friend had placed for my Lord's consideration relates to about the offense committed by petitioner is a non-cognizable offense and bailable. But the moment judgment has been rendered, those aspects would pale into insignificance. Offense may be non-cognizable, may be bailable, but so far as applying provision of section 389 where the prayer is for staying of conviction, those consideration probably is not available to the petitioner. But in that view of the matter, on my side, I am saying that what had been found by learned magistrate as well as learned session judge, that offense is serious considering the material of investigation. This is not the case where Honorable Court may kindly stay the conviction of the petitioner. These are my submission, my lords.
Yes. Yes, Mr. Nana, what do you have to say? First of all, maintainability and
I am on
status.
that only.
And
First of all,
status.
yes, my
What
state,
is you? Yes.
yes, I'll
They
make
are seriously challenging your status.
Yes,
Once the conviction is recorded, therefore,
I am
now you are-
I have played my role and it is over for me.
Yes.
Anyway, I'll make my submissions on that, but first, Lord, I will take with my
Yes.
Lord's permission. Kindly see the memo of revision as couched
yes,
and presented before me. This revision, my Lord, the top of it on the first page itself,
yes.
under 397,
Hmm.
read with 401, against the judgment and order dated 20 April 2003, below application exhibit 5, in criminal appeal number 254 of 23 of the court of 8th additional sessions Judge Surat. So this is under 397 read with 401, criminal revision. Then my lord may kindly oblige me. Page number 5 of the memo. Paragraph 15. They have themselves, being conscious, devoted a paragraph about maintainability of the petition. This revision. And I may kindly be permitted to read. The present application under 397 is maintainable before this honorable court in as much as impugn order passed by the learned sessions at Surat is not an interim or interlocutory order. It determines substantial rights of the applicant and his status in the eyes of law as a convict. Moreover, the impugn order sustains the disqualification that appellant has attracted with a section 8, subsection 3 of the Representation of People Act, is entitling him from his parliament membership and representing his constituency Wayanad, Kerala, from where the appellant was elected as Lok Sabha to the Lok Sabha by an overwhelming margin. Even otherwise, Lord, I am on this. Even otherwise, these applications challenging the impugn order shall be maintainable under inherent powers of the Honorable High Court under 482 of the Code, read with Articles 226, 227 of the Constitution of India, irrespective of nomenclature of the application preferred herein. So they are not sure under which provision they are approaching these on the High Court in their respectful submission. The scope of revision, my lord, is well defined. Knowing fully well that scope, in the second breath, they are saying in this very memo petition in paragraph 5 that this can be under 482 as well, or as well as under 226, 227. In my respectful submission, they can't ride both the horses at a time simultaneously. Either it can be a revision only, or it can be a petition, special criminal application under 226, 227, read with 482, or only under 482. But this can't be the position that they themselves are not sure that which proceeding they are filing and which jurisdiction of the High Court they are invoking. Once that is the position in my respectful submission, they are just adding this sentence, nomenclature of the application, irrespective of the nomenclature of the application preferred herein. It cannot be irrespective of nomenclature because that will define the jurisdiction of the High Court. It cannot be. Nomenclature and the provision under which you are approaching High Court is the most relevant so far as the consideration and adjudication of that proceeding is concerned. If it is 226, it stands on one footing. If it is 227 supervisory jurisdiction, it stands on another footing. If it is invocation of inherent power of the High Court under 482, it stands on third footing. And if it is revisional jurisdiction of the High Court, then the scope is different. Therefore, I would respectfully submit that this petition filed as it is not maintainable. Anyway, I was to submit in the opening, but the query came therefore from the state that in fact it requires at least a reply from our side.
It is a revision application more so. It is based on the
various
records which is already
from the memo.
before the court.
I can demonstratively point out, as I have pointed out these aspects. Various factual aspects are stated, which is not at least in conformity with the record as it exists. Record is also not called for as under the revision, either at their instance or at the High Court on its own suo motu, has to call for the record and proceedings in revision. It can't be decided in absence of the record and proceedings. If I have to point out something that whatever is produced, I don't doubt the genuineness of it. But at the same time, as the translated copies are provided, original depositions are recorded in Gujarati. It may change the meaning sometime. Translator may commit mistake also. I am not attributing any further thing. So first of all, at least RNP, if at all, if it is revision, is required to be called. If it is not revision and 226 petition, then reply is required in my humble submission. If it is 482, again reply will be required.
So in this situation, at least at least I am not clear, or they may make their breath clear that we are invoking this jurisdiction. If it is purely they are invoking revisional jurisdiction, then on the basis of the material.
Then if you want to file your affidavit, you file Tuesday.
Lordship.
I am not granting any
No,
further.
no, I will not take any further.
I have to complete these proceedings. That's all.
My lord. Tuesday I will file. I'll give them copy if
In
possible by
advance.
Monday,
Yes,
late evening.
no longer time. So now we have sufficiently invested.
Yes,
time.
lot of
We
time.
have to conclude.
I am obliged.
That's all.
Can I just take 5 minutes on this primary objection?
Yes,
Just 5 minutes.
yes.
Okay.
Well, since your lordship will be rising, I don't want your lordship to rise under a misconception
No, no.
propounded by my learned friends.
Yes.
Just now, apparently, they have not read the direct Supreme Court judgments. We have just been accused of not knowing whether we are fish or fowl, whether we are duck or drake, because we don't know whether we are 397 or whether we are 482 or whether we are 226. Now let's just note these two answers directly covered by our lordships. We have taken care of. Obviously, it is not for me to get up and say, look, please note, my lords, that I am maintainable. I can only reply and rejoin that after he raises the objection.
Yes.
And I was certainly not here, Malus, to give him an idea to raise an objection or to invite one. Now, therefore, Malus, what is the answer to this? Number one, what is this order? This order is a final order, finally rejecting my stay of conviction. Does this order leave anything? Malus, your lordship will just read the judgment. Trappings of finality. Your lordship has got this final interim interlocutory age old, 100, 200 years old. In the civil side, your lordship has a Gujarat case. It started from Gujarat, Shah Babulal Khimji, which very famous case went to Supreme Court. Finality is, first, I'm giving your lordship 4 answers, clearly covering. Is the order under appeal final where the subject it decides? Answer is yes. I have nothing else to do by way of interlocutory approach in that order. In the course of a proceeding, there are many issues which will not finally dispose of the main appeal, but will raise and decide issues which in the course of the appeal are final in themselves.
The final effect of and the final resultant effect of that it is to
Of
be-
this order is the first test.
Yes.
Is it final? Clearly, Balaz, the conviction, which is my mainstay, without which I can't survive on disqualification, without which I can't survive on fighting elections, without which I cannot do anything, is finally decided. It's not interimly decided. It is not interlocutorly decided. I have nowhere else to go. Second, directly this issue is decided in Madhulime. Turn to that, Balaz.
On page 192 of the blue file.
Now, Balaz, the Madhulime is 1977 4 SCC 551, 3 learned judges separately held 2 points. And I will deal with the second point first, because it disposes of the objection completely. Supreme Court has decided this conclusively in a criminal matter 50 years ago or 40 years ago. And we are told, Malus, that this is not the law. Note here, Malus, it was a worse case. They said, Mr. Madhulime himself said that this trial is bad because the sanction is not properly got, and 1 or 2 other things in the course of a trial. He went to the court. The court held that this is so and so. He went in revision. The revisional court said it is interlocutory and it won't. Supreme Court reversed. Now see that, Malus, para 12 and 13. And I'm sorry, very important, defamation case. Defamation case. Directly relevant on all 4s, even on facts and context. Ordinarily and generally, the most exhaustive dealing 40 years ago, Malus. This point doesn't arise now. Doesn't survive anymore. Ordinarily and generally, the expression interlocutory order has been understood and taken to mean as a converse of the term final order. In volume so-and-so of Halsbury, a judgment or order may be final for one purpose and interlocutory for another, or final as to part and interlocutory as to part. The meaning of the two words must therefore be considered separately in relation to the particular purpose for which it is required. In general, a judgment or order which determines the principal matter in question is termed final. The principal, this is the point, brothers. What is the principal matter? Either I have a conviction of stay, a stay of conviction, or I don't have. That's final. An order which does not, I mean the next quotation, brothers. An order which does not deal with the final rights of the parties, but either is made before judgment or gives no final decision on the matter in dispute, but is merely a matter of procedure, or is made after judgment and merely directs how the declaration of right is already given are to be worked out, is termed interlocutory. I'll skip all this, brothers. A Kupuswami, they refer to, brothers, Solomon, the old judgment of the House of Lords, and just turn the page, brothers, to 199. Applying the test almost on fact similar to the ones in the instant case, it was held that the order and revision passed by the High Court, at that time there was no bar like 397.2, was not a final order within the meaning of 205. It is to be noticed that the test laid down was that if the objection of the accused succeeded, the proceeding could not have ended, but not vice versa. Now, may I skip it with your Lordship permission? There is nothing much relevant, and start from about 7 lines below. If it were so, it will render almost nugatory the revisional power of the Sessions Court or the High Court conferred on it by 397. On such a strict interpretation, only those orders would be revisable, which are orders passed on the final determination of the action, but are not appealable under Chapter 29. This does not seem to be the intention of the legislature when it retained the revisional power of the High Court. In what cases then the High Court will examine the legality or propriety of an order or the legality of any proceeding of an inferior criminal court? Is it circumscribed to examine only such proceeding which is brought for its examination after the final decision and wherein no appeal lies? Such cases will be very few and far between. Then they cite Chamarbogwala, etc. and see after that. On the other hand,
Last 4 lines.
I'm grateful, brothers. I'm very grateful. But just before that, 2 lines also fell after. On the other hand, the legislature kept intact the revisional power of the High Court. On the other hand, put a bar on the exercise of that power in relation to any interlocutory order. Then the last 4 lines, I'll jump to that, brothers. Yes. By a rule of harmonious construction, we think that the bar in 397.2 is not meant to be attracted to such kinds of intermediate orders. They are intermediate because they don't decide the trial. You don't convict me or you don't acquit me. But they are still final, what they decide. They may not be final orders for the purposes, yet it will not be correct to characterize them as merely interlocutory orders. It is neither advisable nor possible, but this whole para is very important, to make a catalogue of orders to demonstrate which kinds of orders will be merely, purely or simply interlocutory, exhaustive lists, etc. One thing, Malal, before I leave this, is para 2. No, this is the beginning of the facts. Para 5. Look at what he appealed against. Para 5. This is important. The defamation case is very important. I forgot to mention it. My learned friend rightly reminded your lordships. Defamation is what is mentioned in para 2, 4th line of para 2.
Yes.
4th line of para 2, defamation case. Now come to para 5. The sessions judge rejected all these contentions. What are the contentions? But I'm sorry, para 4, just see 4. The appellant raised 3 contentions. Even assuming the allegations made against Antule were defamatory, they were not in respect of his conduct in the discharge of his public functions, and hence so and so. The sanction given was bad. Third, Chief Secretary did not apply. Purely, in that sense, interlocutory, because they don't decide the trial finally. But, 5, the sessions judge rejected all these contentions. The appellant challenged the order of the session in the High Court revision. Then, it came up to the Supreme Court. Now, the second point. My learned friend, this part is clear, it is maintainable, and the last para, as my lord says, is directly on point. 3 judges 40 years ago. It has stood the test of time. My learned friend added one thing more, which I'll end on this. He said, this appellant, this revision petitioner today, me, does not know whether he should enter like a 482 petitioner, or as a 397, or as a 226, or as a 227. The first part of this judgment has something very, very much more important, which my learned friends, brothers, should be advised about. It says, now I am anyway in revision, and the revision is maintainable. I'm finished on that. I'm not repeating. Suppose I had come in 482 or I had come in a non-maintainable 397. In both those cases, your lordships has the power to convert it and hear it like 482, is what this court is saying. So instead of making me not knowing whether I am fish or fowl, it says that the court can decide, I will treat you like a fowl or a fish, but I will do justice. That para is important. Para 10. That's the first part. In this case, it says your 397 is maintainable. Suppose it was not maintainable, I will decide you the 482. 10. Suppose there is no identity crisis, which I will have or lordships will have, in the event a lordship wants to treat me the 482. Just see the lower part. Actually, the last 5-6 lines will be enough. But the whole para is important. I will not read. The lordship will note the whole para. But just see the last 5 lines now. The label of the petition filed by an agreed party is immaterial.
Unfortunately, I am having the underline mark.
Oh,
Which you have.
Oh, I see.
For your purpose, you have underlined that line.
I'm sorry. I'm sorry. I'm sorry. So therefore, anyway, the last 5 lines, the label is irrelevant. The High Court can examine the matter in appropriate case under inherent powers. The present case undoubtedly falls for excise. In the event, there's no problem. The second part, para 12 and 13 says you're okay. But in the event they were not okay, your lordships can do it. Well, it's
in the last part also you have marked the certain portion of that.
Well, I'm very
It's also important.
This is
But it is relevant.
I did not know what copy was handed over to your lordship. I'm sorry.
No.
Sorry. Can we replace it, Wallace?
There is no.
Wallace, there are some judges we have in Delhi High Court whose instructions, practice direction is issued to say that you must give me a written submission of 3 pages. But with that, you must give me case law. And there is a learned judge who retired just now. It's a very useful practice. The judgments must all be put in 2 or 3 color codes. It's prescribed in practice. One is blue, one is red, and leave the other one for me to put. The judge will put. That is one of those portions you are relying upon. And in case you are a respondent, those portions which the other side has already relied upon. And then the judge will decide. So he loves because marked copies being given.
Yes, we will also love.
No, that was not the intention. That was not the intention, though. Well, it's only one thing. Give me a minute to do one thing.
Yes.
Well, I was only wondering, does your lordship really, in a matter with the entire record here, reply, the record is this, what record, what reply can anybody file? He
I have
can't
not
change.
called for records.
No. I'm saying, reply cannot change anything.
Because he may, whatever he wants to point out, he may point out. So there is nothing remain in the, we conclude the part on Tuesday, that's all.
The hearing,
Everything, hearing and everything would be over on Tuesday, no further time.
Monday evening, right, sir?
Very well.
No, I may file even relevant documents if at all we are relying. Without any reply.
Whatever you rely,
pleadings and all.
if you want to file, you file.
Yes, by Monday evening, we will serve the
Yes.
copy late
So
by 8 p.m. also.
On Tuesday, it will
Tuesday,
be
yeah.
over.
Oh, yes.
Because after 5th, I am not available in India. I have to leave. And before that.
No, we also, we wanted a
We will be in a
judgment
different
this way, that way before that. Last point was 386. That's the one point we made.
Yes.
386. 2 minutes. I forgot.
Yes,
So, I forgot to answer the learned purple. Well, the 386 is the red herring. Just see 378.4.
Yes.
Sorry, not 378. Yeah, 378.4.
378.4. Yes.
My learned friend can appeal or challenge only when I am acquitted. Here he is challenging. Here he is challenging when I am convicted.
I am not challenging it.
No, not he. They will accept the interpretation. I'm not on. I think he's the prosecutor's argument. I'm not on the actual. I'm saying the interpretation. He says I always have a right to speak. I have a right to audience on this. The right to audience in 378 bracket 4, your lordship gives to him because he walks away scot-free. He acquits and he walks out of the room. So your lordship says if he's walking away scot-free, please give a right to the PP.
Only to the complainant.
Not PP, complainant to object. Now, well, let's suppose the right is given only to the complainant to object, even when he's walking away scot-free. Then how can there be a right when he's convicted? Well, let's kindly appreciate what I'm saying. Your lordship's policy is to not let me go scot-free without a challenge by the complainant. The policy can't be that when I'm being convicted, somebody other than the complainant will again have a right in a bilateral offense, in a locus offense. So it's contrary to what 386 doesn't say anything of this kind.
His contention is also dealt with.
So would your lordship like to have it at 11 or 2:30 so that will not be?
If you
No,
come-
subject to your lordship,
Yes,
will not be.
because now we are having only 10 to 11 matters.
We would
So
prefer
after that, we
2:30.
immediately start this.
If your lordships can consider 2:30.
2:30.
I mean afternoon session.
Yes, sir.
Tuesday afternoon session.
Yes, second half.
Obliged. Very deeply
Second.
obliged. Very deeply obliged. Very deeply obliged.
Obliged.
The learned council concluded their arguments. But at the same time, the learned counsel, Mr. Nanavati, appearing on behalf of the original complainant, wants to produce certain documents. So, in the interest of justice, the document is to be produced on record on or before Tuesday. Yes, on or before Tuesday, and the copy is to be served in advance to the other side. That is the petitioner.
Yes, I have said this.
Latest by Monday.
I have stated
That's
this.
all right. That's all right. No problem.
I'll come
I'm
to your
observing all
home.
these things.
No, nothing. No problem. No problem.
When I stated it is
Yes,
stated.
it is to be served on or before Monday. The matter is peremptorily to be heard at Tuesday afternoon.
Mr. Tolia may be permitted to file his
Yes,
appearance.
yes. The learned counsel, Mr. Harshit Tolia, who is appearing for the original complainant, permitted to file his own. Respondent number, please.
Obliged.
Yes.
Sorry, sir.
Anything is remained?
I will take it.